És akkor már a wiki ezzel tudja pipip, pipip, szokásos.
Jobb egérgomb? Vagy mi? Ez nem egér?
De egér, egy escaping, sima egérgomb.
Ja, jó.
Erre az alulról a harmadikra rá,
Oké.
ott egy
és ott
sima egérgomb, és ott a full screen mód alul.
Jó, oké, látom. Jó.
És utána, ha wiki abba
Mindjárt.
hagyta, akkor ugyanazzal az
Mert én majd utána úgyis állok. Úgyhogy gyere. Nincs. Akkor neked szép. De felmondok neked
Hát akkor tolódjunk egy kicsit arrébb.
Szilveszter van.
Picit tolódjunk arrébb. Jó, mert akkor így, és akkor így. És akkor én a virágcsapó leszek.
Egyen kevesebb van a szék. Vagy akkor ide rakod és arra?
Megtelni rá.
Egy nap olyan érdekeseket olvastam sokkal az EBC-re a pilotról.
Jó, én majd jelzem.
Igen. Ez a LinkedIn-en az a link, hogy fel tudtam regisztrálni, és fel tudtam azt
Igen.
10 perces. Azt te kipróbáltad?
Meg így, hogy nem kell kimenni a biztoshoz, még egyszerűbb lesz.
Az lvcpilot.eu-s honlapon regisztráljál, és akkor...
Tisztelt Hölgyeim és Uraim! Kezdünk. Mindenkit nagy szeretettel és tisztelettel köszöntünk a 2025. évi adatnap konferencián, ami így 2024. március 21 után lassan egy rendezvénysorozat. Igyekszünk ezzel egy hagyományt teremteni. Ez egy kétnapos rendezvény, nemzetközi vendégeink miatt már tegnap délután 2 órakor elkezdtük ezt a tulajdonképpen beszélgetést, amely itt ebben a gyönyörű, mondtam volna magamban, hogy Székesegyházhoz hasonló környezetben, de nem volt eléggé székes ez a ház, úgyhogy most a moderátorunknak is szereztem még. Tehát, hogy ebben a környezetben online és személyes jelenlét mellett folyik a konferencia, és nagyon sok csatornán zajlik. Idén streaming YouTube csatornán is követhető magyar és angol nyelven, és folyamatos a szinkrontolmács szolgáltatás is. Köszönjük szépen ezúton is a kollégáknak a segítséget. És van még egy csatorna ma, mert van egy specializáció, egy adatgazdasággal kapcsolatos kis szekcióit mögöttünk a dékáni tanácsteremben, és párhuzamosan zajlik 2 esemény. Hogy nagyon figyelnünk kell arra, hogy az időkereteket tartsuk, és akkor menjünk szünetre, amikor ők is. Ez egyrészt megkönnyíti a keveredést, de hát, hogy aki úgy érzi, hogy ott is részt venne, itt is részt venne, akkor tudja.
This is for Hungarian. If you want to find our webpage, you can use that QR code on the overhead. It's also in the leaflet. There's also a publication to our vocabulary at the end of the leaflet, which helps you find your knowledge if you talk about regulations that can be the class. So that's all. Now, I would like to give the floor to Mr. again. Thank you so much. Reckless. Post. And the word is data controlling. We have modified and person-based sessions. What happened with the recent years is not just from students, but also from social. So legislation has made digital services available with built-in a new level of person-based data controlling. One software director is continuously launching digital services like authentication challenge this digital digital repository, and also those that challenge starting this year. These are no longer theoretical possibilities, but reality, and they raise also a serious question. Esa persona llamó la posibilidad de llegó a proceder que
about the necessary to use these data. When I want or when I have to, when such data have to be used, I have been working for Itemsoft for 10 years, and my experience is, but what we like is, if there is a legal regulation allowing us to use the data, because that's much more simple. Then there is no dispute. Consent cannot be revoked. You can build processes on the basis of this, because those data will be certainly there. So that's why we would challenge this based on the experiences of the recent years, because on one hand, when the legislator decides that data controlling is deemed to be necessary, then they consider that on that abstraction level in those processes, whether these data are really necessary to be controlled, and they use their best efforts to set a minimum level. So set a minimum level of required data. But if we want to provide services, indeed, if we want to provide services which are good, then it is not sure if you start from baseline level. So based on our experiences, consent-based data controlling in the last 2 and 3 years, it also puts much emphasis on mapping the need of our potential clients, and we see that they don't need the minimum level. They would like to get services from the public sector, which they are used to on the market. So once I shared my in 100 times, now do I have to concentrate 100 times? So there's a need to allow clients to decide that once they take consent, actually do controlling, then we should be valid and that will be revoked. And the need of clients not be enough. I have to EU regulations at random. So we have to strike a happy balance between using the data in such a way that it has a positive advantage, but at the same time, I don't impair the data privacy. So we must not expose individuals to too much power related to data, which is maybe critical in sometimes. That's why we try to offer services which are consent-based. But based on the previous information, this is some muddy terrain, because what happens if we get the consent from the client and then the client starts to revoke it? So we have to constantly pay attention to what we had not paid attention so far. That client clients might make decisions otherwise. So when we talk about data and personal data, when I want to use my own data, I have to verify these data. How can I verify them? Of course, I have to use a kind of ID card or a document stamped. This is the classical way to do it. This always works. But recently we also have examples, and of course we use our best efforts to reduce paper-based use of documents to a minimum or to zero. Since January, February 2023, the one-stop document is working when we said that you don't have to have your driver's license physically with you. You need not carry your driver's license with you. The main thing is that you should always have a personal ID with your picture on it, which is suitable for identifying you in case of police checks. So the next thing is related to DAP app. When this appeared, it had a function up to date that when the police stops you, you can use it. We cannot use it anytime and anywhere, but when the police checks you, you can use it. You need not use a physical personal document. So I can sit into my car having just my mobile phone with myself. There is also a possibility to share my data, but without authentication. But these data are always up to date and always in accordance with the registration of the public sector. So the next step is, since this February, and here we arrived at authenticated data sharing, we have the possibility to that certain data like your place of residence or your tax number or social insurance number or driver's license can be proved or verified in the form of an authenticated PDF file authenticated by the DAP application. So we see that this is not fully known to the clients, to the users. Of course, industry-related standards have adopted them in part because the legal regulation said that that certain page of the residence card can be copied, status copied, and so on. Of course, the data to be shared in an authenticated way can be extended. It is important to emphasize that these authenticated PDF files are not yet suitable for personal identification. You still have to identify yourself by using your personal ID card. But the target is to arrive at a point where the personal identification can take place also in the physical space to using your mobile phone application, because in the digital space, this is reality already. This is a picture from my colleagues. This is what an authenticated PDF generating interface looks like in DAP application. I can pick the menu, and then I can pick the type of the personal document to be produced in a digital PDF file. So when our mobile phone is suitable for personal identification, then we arrive at the point of a wallet. I have a great many pictures there, from certificates, from requesting certificates to the personalification of the wallet. We will talk about the wallet in the future as well, but I would like to draw your attention to the fact that the ultimate purpose is to have a EU wallet, or to make it available. Two preconditions have to be fulfilled for this. We should have the IT product that is capable of providing it, and also the right environment. We have to have the certificate issuers, supervisory organizations, and a legal framework for this. But we are not so far. On both sides, we still have gaps to be filled. But yet, together with this, the national digital wallet is already functioning, and certain functions of the EU wallet are going to be adopted as well. And we hope that in the not too far future, we will arrive at a point that this data wallet will be usable also on international level, also within DAP. Also this authenticated PDF and also the wallet can work in such a way that stakeholder or the person concerned is active. He requests or she requests, or she hands over or he hands over the data. So the wallet is really like having a physical documents in my pocket. But we see that we also have, there is also a need that the user needs not be active. When a user wants that in a certain moment the market service provider the user is in contact from could take over the data from public authenticated registers, or such data could be followed up by the public sector without the active participation of the user. We do have such applications, like the application to be used when your personal data change. I don't have to pick the data I want to send them. Consent-based, in case of consent-based data sharing. This summer, the process will be available, and also market players will join in when this consent can be granted in a way integrated into the process. For example, I sit in front of the web page of a market service provider. I want to conclude a contract with him, and he said, please share your data, this and this data, or please consent to or taking your data over into the state-owned registry just this time. And if it is justified and needed, in case of permanent legal relationships, then you should continuously grant us the possibility that when we need your data, for example, we are updated from the about the changes. So if the stake of the person concerned gives his or her consent, then the DAPE service provider keeps a register of the consent of Victoria Zeleny, that in the next 2 hours or in the next 2 years, the Miracle Ltd would take over her data about her place of residence once or several times whenever a change happens. And as long as this consent is valid, we will hand over the place of residence data of Victoria than to us. Of course, this has an expiry date above all, but the person concerned can make a decision anytime to revoke this consent. We don't register whether these data can be controlled. It is not this point where it can be revoked, what the service provider can use the data for, but that the data can be taken over from public state-owned authenticated register, so the consent to this can be granted or revoked in this service. So this is how the application is going to look like. I am on the web page of the fictive bank, and when the question is raised whether I consent to handing over this data from the service provider, then it would jump over to our web page, and when they grant this consent, then his or her data are taken over from the state-owned registry. This is what it looks like. Every kind of data are uploaded, and our plan is to set up some data packages. This is a serious question, because we should grant independence to the persons concerned, but we also have to protect them, sometimes from themselves. And that's why we thought that we will first think in terms of data packages. So the data which deemed to be necessary will be offered, and maybe in the future we will see that the method has to be changed, and we should allow to the persons concerned to pick whatever they want. But maybe in the first round we would be in a better shape to protect their data. So these are the free services I wanted to outline: the authenticate, take it PDF file, the wallet services, which is a kind of evolution, and the consent-based data supply. These are the three things I wanted to talk to you about. Thank you so much for your attention.
Köszönjük ezt a tartalmas előadást, amely kellő alapot biztosít szerintem a következő beszélgetéshez. A beszélgetés során kimondottan a hozzájáruláson alapuló adatkezelés és az adattárca alkalmazásának gyakorlati helyzeteit kívánjuk körbejárni, ahol különböző szereplők fognak, és különböző szereplők szemszögéből nézhetjük, illetve hallhatjuk a véleményeket, és most a panel résztvevőit szeretném bemutatni. Szilveszter Nórát, aki az NMHH e-szolgáltatás felügyeleti osztályának a vezetője. Szabó Áront, most akkor sorban megyek visszafelé, Szabó Áront, aki az E-Group ICT Software ZRT-nek az informatikai biztonsági tanácsadója, Kis Attillát, aki a NAIH-nak a társadalmi kapcsolatok főosztályának főosztályvezetője, és Bendik Tamást, aki a NAIH elnök helyettese, és hát készültem jó pár kérdéssel. Az időnk nyilvánvalóan behatárolt, tehát 10:30-ig tart ez a panel. Az utolsó 8 percben kívánjuk a közönséget megszólaltatni, illetve hogyha kérdések vannak, akkor ezt úgy terveztük, hogy az utolsó 8 percben tudnánk erre lehetőséget adni, de természetesen meglátjuk, hogy hogyan fog élővé válni ez a beszélgetés. Legelőször is egy kicsit a múlttal kezdeném, hogyha visszatekintünk az adatkezelésnek a történeti előzményeire, akkor hogyan változott meg az államnak és az állampolgárnak a viszonya az adatkezelés szempontjából az elmúlt 30 évben? Van-e bármilyen tanulsága a magyar adatkezelési múltnak, ami figyelmeztethet bennünket most? És mindenki előtt ott van egy mikrofon, amihez nem is kell közel hajolni, hanem csak a gombot kell majd megnyomni, hogy az zöldre váltson, és akkor elvileg hallható lesz a hozzászólás is. És hát azt gondolom, hogy szabad-a.
Nem. Látom, hogy rám szegeződtek a tekintetek. Üdvözlök minden résztvevőt. Tekintettel az idő karcsúságára azt gondolom, hogy ezt a témát viszonylag gyorsan körbe tudjuk járni. A kiinduló pontunk az a rendszerváltoztatás lehet, amikor is ugye a jogállami alkotmányban alapjogként megjelent a személyes adatok védelméhez fűződő jog, és ekként ugye ezt az alapjogi védelmet, illetve ennek az alapjogi védelmnek a tartalmát az Alkotmánybíróság határozatai töltötték meg tulajdonképpen olyan részletes tartalma, amelyet a jogalkalmazóknak is figyelembe kellett venniük, illetve a jogalkotónak is. Itt, ha ezt egy történelmi távlatban nézzük, akkor szerintem talán azt lehet kiemelni, hogy az első víziója az alkotmányozónak, illetve az Alkotmánybíróságnak, ha információs jogokat tekintjük, akkor az átlátható állam és az átláthatatlan polgár volt, tehát azt az információs monopóliumot, amely az államigazgatásban megjelent, azt szerette volna oldani, és ennek megfelelően több olyan alkotmányossági követelményt dolgozott ki, osztott információs rendszereknek az alkotmányossági követelménye, illetve a profilalkotás tilalma, mindenki ismeri ezeket a korai döntéseket, amelyek sokáig érvényesültek. Aztán az elmúlt néhány évben, évtizedben azt látjuk, hogy már nem az állam vált a legfontosabb adatkezelővé, vagy a legnagyobb terjedelmű adatoknak, legsokrétűbb adatoknak a kezelőjévé, hanem piaci szolgáltatást nyújtó adatkezelők, és a leginkább közelmúltban pedig azt látjuk talán, és hát nyilván ezzel kapcsolatban születtek mindenféle uniós és tagállami jogi normák, amelyek ezt az adatkezelési terjedelmet megpróbálják korlátok közé szorítani, és ehhez képest most a közelmúltban szerintem a DAB törvény is erre egy jó példa. Azt látjuk, hogy az államok, ideértve Magyarországot is, felismerték, hogy vannak olyan adatok, adatvagyon, amely az állam kezelésében van, amelynek a további hasznosításával kapcsolatban számos lehetőség áll rendelkezésre az állam és intézményei részére is, nem csak a magán szféra részére, és egy ilyen visszarendeződés látszik a korábbi osztott információs rendszerek alkotmányossági követelményéhez képest, illetve a profilalkotás tilalmához képest is. Nem véletlenül, ahogy a DAB törvényhez egy alaptörvény módosítást is el kellett fogadnia az alkotmányozónak, ezt a szemléletváltást is tükrözve. Én itt megállnék.
Ha lehet, akkor én folytatnám. Egy másik aspektus volt, tehát én ugye történetileg részt vettem viszonylag hosszú ideig szabályozóként is, és most már jogalkalmazóként is az informatikai szolgáltatások szabályozásánál. Tehát, hogy 2001 óta ez a fajta jogi szabályozás ment előre, de teljesen más aspektusból. Tehát ugye ameddig nem volt GDPR, addig nem is mihez volt hozzányúlási alap se itthon, se Európában. Ott inkább a felhasználói jogok meg védelem volt előtérben. Jött a GDPR, és elkezdtek az ágazati szabályok is
were implemented, like telecommunication. For example, in the field of telecommunication, and the last regulation or guideline is from 2002. So the regulation of information services from a data protection aspect, this is a huge challenge globally and at the EU level. and then there's a need that it has to be specifically regulated. So from an IT person, the data protection perspectives, it's difficult to digest. But if I read these 2002 guidelines, I will not know logically how to separate these distinct requirements. But sometimes we need to physically separate in the digital wallet the information, and lots of things need to be rethought. And information regulation is like that. And as this is a highly innovative area, there's a need to foresee 2 or 5 years ahead what will come next. And it's difficult based on my experience. I wouldn't be able to say what will happen in 5 years' time. And back then, when we were working on the regulations, we didn't know what would be the situation today. And now we can say that in the DAP app, there is an electronic signature that we can use, but 20 years have passed in the meantime. So this is such a special field that you cannot really forecast what situation or status will emerge. So perhaps we were not thinking correctly back then, so we need to rethink lots of things, reconsider lots of things, and regulations amongst others. So and we can see that there are lots of data types, and I would focus on the same type of data or data categories. The question was what changes we have seen in the past period. It was very interesting that data protection versus data security, because we need to identify or authenticate someone, because otherwise we won't be able to proceed with the procedure or with the process. At the beginning of this process, there were personal identification code and other data that were really considered sensitive data, and then the social security code or number. And in public administration, the four key natural data. And when the EIDAS was started, there were requirements that we need globally unique data, lifelong data that could be used lifelong. And then we saw that there are certain specificalities in all the countries, like in Hungary, in the four key data, it's the mother's name, for example, in Hungary. However, it's not part of the key data in other countries. So if we start an overarching process within the EU, then we only have 3 data out of the 4, and now we return to the point that we will have a new global, unique, lifelong identification data or set of data that everybody has a legal basis for, and this can be a funding stone. There were other identification data that could have been used, but not all the players had a legal basis to use such type of data. With the DAP, with the digital citizenship, we have this legal basis, so we can start building on that. The consultation submissions of the Data Protection Authority are submitted to us, and that is why we face these new requirements and challenges. with a two-step authentication procedure. We received a tsunami of submissions. People were protesting that they don't want to provide their data, and now we arrived to the Big Brother status and the monopolistic state supervision and surveillance. However, for example, a Google account already knows lots of data about people. So now the DAP, the Digital Citizenship Initiative, is a huge opportunity so that we don't have to store photocopied ID cards in different qualities or photocopied resident card and so on. And we have a newborn baby, and we had to provide lots of data considering our ID cards and so on in a photocopied version. So this was a good direction, this new direction that data can be transferred and handed over in a secure manner. And we departed from these photocopied versions of our personal data. However, I wouldn't mix the consent-based issue here. So this is a very good package of regulations. We need to know what log file had to be stored and for how long. However, if the data subject requests this service, I would say instead of consent, it should be an agreement to my data being processed. So we will see why it is not really a consent, but an acknowledgement, or if persons are afraid of DAP, the digital citizenship, and they still prefer to have their ID cards photocopied. I would stop here on the consent issue. And if you look at the legal basis of consent, then consent, is it the best legal basis, or it's the most convenient one? Or is consent, is it always voluntary? Or sometimes you would need a legal basis either in the form of a law or any public interest or whatever. I would grab the opportunity to continue with Attila's thought. The fact itself that the citizen has a right to make a choice if they wish to use a service provided by the state and for what purposes. On the side of data protection, it is a good point of argument, and within the context of GDPR, it does not necessarily mean that Article 6 in GDPR serves as a legal basis for data processing. On the other side, well, within the concepts of GDPR, accountability is placed on the data controller, so that the data controller determines the legal basis for processing. Whereas, as it's a European Union law, it gives possibility in a limited manner any freedom of movement that to add requirements or to add anything to the GDPR requirements. And based on the consent issue, the member state does not have an authority to make addendums. However, based on legal basis, you have this freedom as a member state to make amendments. and the data protection authority and the courts are competent to decide if data controllers determine the legal basis for processing. But I think there are lots of argument for reviewing this from a task-related basis that data subjects should determine if they would like to start this data transfer to the service providers. So IDOMsoft as data controller may not decide that it won't transfer the data in case of a consent. However, a normal service provider may decide at any moment that they don't wish to transfer such data because there's no obligation to transfer data. So this is a limping solution to some extent, the consent-based issue. Just a small addendum to Tamás's thoughts. I know the rules of the digital wallet, and there's no, it is not determined on what basis the digital wallet handles or processes data. However, there are general guidelines demonstrated and determined that the legal requirements need to be met. However, when making a choice of the data processing, the method of data processing, and that you need to pay attention to the physical division of data processed. So the user must have sole control over the data, which is impossible. This was tried by the regulators in case of the electronic signature. So in a remote key signature provision, so there's a clash of interests and requirements here, because these general regulatory expressions are just put in the bag, and then the regulator may find a solution. So in the EU projects, this will be resolved somehow, but then everything is placed in the field of technology, and as a legislator, I need to figure out what sole control means in this context. And then we can have an argument with Victoria if we were correct or not in figuring out the solution. In connection with the consent-based data supply, this is the name of the data supply, and we think that this gives a good description for the user, that it's their decision, it's their choice, that you can have a say in what will happen. There are 4 players in this story. There is the citizen who has the data and wishes to use this service, and there's a third-party service provider with whom they have a legal relationship, and there is the DAP service provider, the digital citizenship service provider, who helps the registrator to have a streamlined data supply process. So all 4 players have a different entitlement to such data, but we think that the naming convention of this service refers to the intended content. I'm not trying to figure out here 6-letter abbreviations though, but this name is the name of a service that makes a call upon the user. And the other thing is that I think it's evident for everyone, but I think we should still say it out, that Information Act distinguishes between 2 legal bases, and in contrast to that, GDPR has 6 types of legal bases, and it doesn't mean that item A refers to consent and all others refers to something else. and then the others might correct me, but they think that both the Information Act and the Data Protection Act describes that if there's a contract fulfillment requires data supply, then consent must be deemed to be given in that. So tell me if, or contradict me if I'm not right, but I think when we are entering into a contract with someone, I can say that I have entered that street and then we must process data, but then let's give an example when only consent is taken into account when processing is concerned, but it's not needed, and I won't be in a better situation that someone processes my data. Because if I have any disadvantage from data processing, that it's not appropriate consent. So I would like to connect to the thoughts of Nora. I understand the logic here as a lawyer. However, as an IT person, I cannot do anything with it, or as a service planner, it's very difficult to do anything with these terms. And when we try to handle the roles of these four players that I mentioned before, it should be clarified on what legal basis these authorities are built upon. We need to see that it's difficult to draw the line as to where I want to do something, and from what point my will or my intention does not matter. I think it's very difficult to draw this line, and I think you have an example from your everyday experience, everyday life, that it's not very simple to determine what would have been the right solution in a given case. We have very short time for this discussion, I'm afraid. I would like to highlight, to start, that a certain group of data subjects are very conscious, and if they see the word that there's consent, and then they can withdraw this consent. For example, they opted in for a newsletter, and now they enter the opt-out function, and their consent is withdrawn. And I think the confusion is there, that if there's a consent, the word is used here, then people confuse it with my intention that I want to enter into a certain contract. That person is not aware what would be the legal consequence of that decision. And if they say that, if the data subject says that I want everything erased, however, if the data controller said that I will not erase data used before, or, for example, the Act requires voice recording when there's a call center situation. And people think that they might just erase a certain voice recording. However, the data controller has the obligation to retain this voice recording for 5 years. So it cannot be just erased. So if someone uses a video recording and there's an obligation that you need to retain the recording for 1 year, so there's a confusion that based on GDPR, you have informed consent, and it's voluntary and so on, and you have the right to withdraw it. However, the pre-GDPR Hungarian language context was a little bit different from what logic is applied to GDPR. So this is the greatest reason for confusion, that there was a different situation then. So in this legal relationship, depending on the players, there will be a different legal basis referred to. because it's different that if a third-party service provider provides the service, or if the state provides this service. So I would like to join my thought to your concept that this is an individual decision, but this is not in the understanding of the GDPR's consent. Just very quickly, I would like to join the people of uncertainties. So even before the digital citizenship, there was legal regulations. For example, due diligence purposes, a law firm has to perform such processes. And if I can recall, in the student loan program, there was a different idea about giving consent. Or if in the e-identity card issue, you can read lots of data from passports or ID cards, but there's an EID part which stores address-related data. So even if someone starts from a different aspect, the process pops up windows as to what consent or what permission you give to the service provider. I don't know if it's legally considered a consent or not, or just a simple permission. It should be clarified. I would like to add that much to make it even more confusing, that not only the actors and the data subject has different legal basis for data processing, but between the data controller and the data subject. So even if it's agreement to or consent to data processing, the thing is that I request the data controller acting on behalf of the state to transfer the relevant data in an authenticated form. So what do I do in that case? The data processing operation that was previously based on an authority published document and that was photocopied, transferred, and so on. Now I authorize, obligate the state that provides a state to do this. So if I look from a private law perspective, the state is like a delivery agent or a proxy that ensures my obligation to transfer my data or identity to the service provider in an authenticated manner. If I want to go very deep, the legal relationship between the data controller and myself as a data subject, there might be a requirement to authenticate me or to identify me, like a bank, for example. So it's not a B point, but a C point data processing relationship. And the state's role as a mediator extends to that role that the state published previously these identity cards and these documents. Now it is supplied in an electronic manner and method. However, the basic fundamentals should be the same. So this does not make it simpler, but even more confusing and complicated. My question is, what benefit the data subject and the data controller has to base data processing based on consent in this process? So what's the benefits?
Lebeg akkor még a kérdés. Átnyargalnék az országhatárokon túlra, és elsősorban EU szabályozással kapcsolatban kérdeznék az EIDAS-nak A digitális személyazonosítás forradalmasítása lenne most a következő kérdés, vagy ez a fókuszban, hogy képes lehet az EU arra, hogy egy ilyen egyetemes szabályozás hozzon létre, természetesen aztán úgy, hogy figyelembe véve, hogy a tagállamok meg a saját útjukat járják.
Yes, this regulation of the EU by AIDAS exists. This was modified last May. The second version of it is valid, and within this specific chapter, the first chapter is dedicated to the systems used for personal identification with technically detailed requirements regarding personal identification. Most of the member states have already shaped their own system. In April 2023, Hungary is the only country which does not have its own established personal identification system, but there is a regulation with standards, specifications, absolutely detailed from the technical point of view, and it is working everywhere. So this is not an impossible step, but technically it is regulated, and which also needs to be audited and evaluated. And after these steps, this is accepted all in Europe. If I live in a member state in the EU, I could identify myself, for example, in case of an accident, just using my mobile phone, using the things in my wallet. So this solution exists. So I wanted to refer to this as well. So in itself, that there is a possibility based on EAS to share data based on consent. This happened also in case of EAS 1, but it is a big progress that at the time we talked about 8 or 10 personal or legal entity data, but now this is going to be a universal something. And we also do have some experiences about this. And I think we will be able to implement this. So this is absolutely good. But I see we as E-Group, together with IRAMSoft, are participants in the pilot EU project. This means that we scrutinize just these things, whether data queries and user authentication, how these things can function in this wallet ecosystem. And over there we see, and I see that here we can progress, that we should have data query possibility, but it was a negative and weird that over there, without the systems existing in areas, many started to work without such systems. We heard that it is we should emphasize that, contrary to other countries, in November 2015, KAVU and all other services which implements just the targets of EAS 1. This is surprisingly well functioning in Hungary. So my question is, so many things were revised by DAP, that if we can, based on the legacy of EAS 1 progress, we can keep our advantage. Maybe we will be first from the last when we pop up with a wallet and with the services integrated behind the wallet. in other countries, they seem to be developing all these things irrespective of all these ideas, which will take much longer time. I don't want to repeat it. We can do it and we can resolve it. The question is what we can do with it, because the data are numbers behind each other, but how we interpret them and how we interpret these data on international level, this will be the real issue. So when we still have to dispute whether the family name, what family name means, and how many parts does it consist of, and so on. So is the place of, is your address the same as the place of residence? This is something we still dispute. So the question is, what do I start to do with the information I acquire about somebody, but I cannot handle this in its context, because I don't know the public administration background of that person. Of course, the basic data, fundamental data appearing in the wallet has already been harmonized, more or less. But if you want to extend this, and if you want to verify useful data using the wallet, then everybody has to understand what these data mean and what these data are good for. It is not interesting that this is an address. We have to know whether this address is the registered offices of a company, for example. If I send a letter to this address, will the company get it? So this is the information which is which counts. So we still have a lot of things to do, but we are progressing. Yes, related to the progress with DAP, we arrived at a milestone where public administration is halfway paper-based, and if we take this as a basis, how can we reconcile the modern DAP and the A4 format application written by all hands? I would start with my experiences. If somebody wants to access their own sensitive data, if somebody wants to get the audio record from the police emergency number, we cannot know if this is really the person concerned, if the patient called, what happened in the background, and because of this, also the authority requests the identification of the client who wants to have the audio records, for example. So they get so far that by email it is not possible, and they have to use a document of full probative, private document of full probative force. If I so there's a distinct difference between the different papers submitted, and we also see, because of the two factors, client portal identification method. We have a two-factor identification system for bookkeepers. So this is something used by the bookkeepers, by the accountants, not by the people themselves. So we don't know whether the documents are coming from the accountant or from the person himself or herself. This is a major obstacle that the legal consequence of the paper-based consent is the same electronically submitted application has. So there are also existing solutions. Also, earlier we had discussions about the interoperability of electronic versus paper-based applications. If something starts on paper-based, then after a conversion service, the app can authenticate it. I don't know whether you have plans like that. For example, at the Hungarian Post, this is also something. We can keep the paper-based access for those who prefer that. I would like to add something to this. The notion of a private document of full probative force based on the civil code. We have 6 or 8 different ways of doing so. So at the very beginning, we had a qualified electronically authenticated signature. And we also have other possibilities of electronic submissions, which are of full probative force. So this happens, this works. So if something really stands its ground as electronic paper, then the legislator considers this to be the same as a private document of full probative force. For us as the applicators of the law had a status when not only the qualified electronic signature, but also the enhanced signature based on documents is used, which was a kind of compromise. But there are also other electronic services which can produce a legal effect or legal consequences also for electronic interactions. So this works. Maybe just one more thing. So the question is, when the social consensus and the legal system gets so far that as to close this process and will not recognize paper-based solutions to have the same legal effect as electronic documents have. We are very far away from this, on one hand, because of the IT awareness and because of the position of IT devices. This should be much better, but we see that certain legal relations move into the digital space. After a certain while, we will reach a point that certain groups of the society will be excluded from being used from initiating certain legal relationships, and this is a serious social-related challenge, society-related challenge. We have, for example, many submissions are received from inmates from jails. They usually used handwriting, and sometimes they know and the legal notions very well. So de facto and de jure, the question is, when do we arrive at a point that you as a legal subject cannot exist without getting your bearings in the electronic space? Maybe it will be earlier de facto than de jure, when there will be a gap, a cliff to be breached by the state somehow. I interpreted the questions in a different way. Shall we get so far that everything has to be made in digital way? And I also represent the IT side, but the question is, the answer is no. On one hand, IT is expensive to create and maintain. A process costs a lot. So that if there is one one person, if there is a person who wants to transport a mother every 5 years, maybe we should not build an IT system for this. But there are such cases which, due to their complexity or their number, does not need to chase that person into the digital jungle where they have to discuss in person what their problem is, which they want to resolve just once in their lifetimes. So these services are good. For example, if I can apply for a good conduct certificate at 11 o'clock in the afternoon, this is good. But there are more complex data or cases when I have to use my free wording when I word what I want. Of course, if I have a form, it can be expedient, but sooner or later, we will arrive at a point when the full lack of the expertise of the user in this. So even if we give a digital support, the person must be there in person who is capable of helping the user. Maybe this support will be at the end of a digital channel after the proper identification, but whether we can bring it to the end, I don't think that we will arrive at a point when everything will be digital, because then we should make everything highly simple, and I don't think that these processes can be that much simplified. Thank you. And last question, maybe we have time for that. If we started with the past, what is the vision and how do you think the future will look like in 10 years? How much can we come close to the Estonians who represent the peak? Is it going to remain a dream? And what will happen to the people who exclude themselves from the whole system? And how can you raise awareness? What do you think? I would react on Wiki. Yesterday evening, I read a study about attributes. It was a Danish example or Norwegian example. It was a fisherman who had a public license for fishing. About a fish served. So until the fish arrives at a restaurant in Vienna, we have attributes certified. Everything electronically, how can it be built up logically? So it has a root, and this could be a main driver for the economy in sectors I did not think of so far. I would not think that also about fishing, IT package could be formed which speeds up everything and makes the economy more vivid. So it does have a significant potential for the economy. So these are wallet services which are going to be shaped now, related to every sector and all services in these sectors and attributes. So this has a future. Of course, there is also a layer of society which is lagging behind, and for whom this cannot be mandatory and must not be disadvantaged because of this, and where the services must be provided also for them. Would I have checked the access of the schools, people in Borsod and Plain County? Then I see that this access to these systems is an improvement for society as well. So all basic purpose is that for the market and for the actors of the public administration, we want to support and electronize and to support their processes. If somebody has a process, and if they come to us, and we treat them as our client, but we also always check what the data requirement is for that process. For example, to conclude a contract, and from which data sources can these data be acquired, and do we have a legal foundation for the access to this data? With DAP, based on the consent, we seem to have the good legal foundations. The question is the scope of data. What can be accessed based on this legal foundation? This will decide who is going to be integrated, how successfully, within 1 year, within 5 years, I don't know. A good digital service is done well when it is evident how a digital service can be used. Of course, you need devices for that. For the service, also devices are needed, which are always costing more than a biro pen. The purpose is to help the user, and I don't want to, for example, the Hungarian tax office could progress well with the electronic personal tax return system, that even academic graduates have a kind of aversion to copy, for example, their personal tax return into a tax return of the tax office. So people don't want to read the information about this. They don't want to get familiar with this. They don't want to understand how to fill in a personal tax return. So the good thing is if we have the fisherman to put the label on the fish to be used for a scanner, for a barcode scanner, so that the fisherman does not need to write with his oily hand and frozen fingers on the fish when the fish was caught, because the IT is there and helps him. So we should not provide IT services to make our life even more difficult. So I would start, apart from data provisos, the most important thing of the digital inclusion is to have a workable service. If somebody moves and changes his name, then they don't have to queue up in front of 8 different user services and client services. But unfortunately, this does not work yet. The other thing is, and electronic personal tax return is working well, for example. And the other question is the trust you put into the service, that the data submitted will be accessed only for purposes. I'm talking about data governance and data assets. So many people still have the big brother approach in their mind, on their minds. That not only my data, but also my services will be available there. And there's a fear in all clients that the digital environment allows to set up a Chinese model-based credit system to see what kind of services I have, and credits can be assigned to it, whether I am a good citizen or bad citizen. I would like to highlight that from the point of view of data privacy, it has to be clear who can access, for what purposes, what kind of data, whether profiles are built on this, and who will be accessed by this profile, and we know who are observing us or not. Thank you so much. So the original question was how we can see the future. I can think a lot of administrative burdens will be dissolved by automation, and the focus is going to be changed mostly. So those working in the application of the law will also be impacted. On the other hand, also the quality of the services is going to change. And on the other hand, I think so the humans will be removed from these processes on the submitter side and on the service provider side as well, which might have a lot of negative impacts. And traces of it can be seen already. So GDPR says not by chance that, for example, for credit applications, these automated decision supporting systems can make ethically wrong decisions. For example, AI. The question is whether we will have a human at the end of that process who can and who will review and change these bad decisions, bad automated decisions. When we go back into the past, who is going to check whether the calculator produced the right result? So the human factor will be excluded. We will see just numbers and attributes which serve material justification. This is the real challenge, whether there will be qualified and courageous people, humans, who are able and willing to dispute the results produced by machines. And I promised to have questions at the end. I would like to encourage everybody to raise questions when in the coffee break. 1 or 2 questions, and okay.
Nem?
De a tolmács.
Tehát ha jól tudom, vagy jól mondom, akkor jelenleg a táptörvény csak az e-aláírásra, meg az e-azonosításra vonatkozóan kötelezi június 1-től a digitális szolgáltatás biztosító szervezeteket, hogy kötelező fölkínálni. Most a kérdésem az, hogy várható-e, hogy lesz ilyen vagy hasonló kötelezés a hiteles adat továbbításra, illetve a hozzájárulás alapú adatszolgáltatásra. Mert az előbbire ugyan szó van arról, hogy azt hitelesnek kell elfogadni, de hogy lehetőséget is biztosítsanak, hogy elküldjen valahova. Tehát
email address or anything, so no one is obligated to do so. For example, in one of the hospitals, it is a notice is put up that you shouldn't even try to do that. Otherwise, they would be obligated to accept such data supply, but then you would need a mailbox for that to receive such data. A certified data should be accepted. The reason or the method how it is implemented, it's a different. They must accept such data supply. It's a question if the legislator need to put everything need to regulate everything in detail. Since February, we have seen that there are places where it's used properly and there are places where it's used inappropriately. So perhaps the legislator or some other supervisory body should intervene in making a proper implementation of the law. And the consent-based data supply, I think it's targeted to me, although I'm not the legislator and I don't have a crystal ball, but I don't know if there's an intention to make this obligatory. We think it's the interest of the service provider to make a possibility for that. And if the users take liking of this service, then obviously those service providers will have a disadvantage who will not offer this possibility. And it's their best interest to access data that at the moment they don't have an authority by law. So, and they don't have to go through the process of scanning, photocopying paper documents. That's an easier thing. However, if they don't want to use it, then they won't use it at the moment. We have 1 minute left. Gabor from the Digital Hungary agency. I would have 3 comments. I agree with Idomsoft that services are not to be developed for the exception of the exception. The other thing is that we do need an awareness or increase the awareness of information security, and we need to support the underprivileged social groups. And the original text of the law from 2014, the interoperability matching is a failure. Certain member states have resolved this issue, but this will remain so in the current status because there's no technical solution for that. The legislators were well before or well advanced against the feasible solutions. And we went to blood testing, or not blood testing, but giving blood with Idomsoft together, and I couldn't register with my DAP, the Digital Citizenship application, to get my data registered. And the other thing is, I would like to ask if there's any other digital repository or digital wallet in addition to DAP within the borders of Hungary. In Hungary or in the EU, you mean? In Hungary. From the EU project, we see that every member state, plus the Ukraine and Switzerland, are represented. Obviously, not only developers are involved in this digital citizenship issue, but I think we have seen at least 15 types of digital wallet solutions. Rockwood and Idomsoft were also involved. But our company also have a wallet solution. As market players, we prepared one wallet solution, and DAP is an implementation, an example for that. So wallet should be a single platform that should support 3 or 4 functions. It should be able to log in users, should be able to authenticate the applicants, and should be able to create an electronic signature in some ways. And for free or free of charge in case of natural persons. But obviously, other players might be able to implement this, or there might be other type of wallets, and not in the form of a mobile application. First, we only had this operated in a web-based platform. So it should not only be a mobile app, but in any other form. So there are more developers, more than one developer actually. Time is up. So thank you very much for this brainstorming or thinking together. And I think it was a very inspiring discussion. And it was very interesting to hear how many aspects exist in terms of an issue or a problem. So I encourage you to continue this discussion in the break. Dear ladies and gentlemen, the Day for Data is continued with panel number 2. I warmly welcome our roundtable participants. We try to involve and adapt to all kinds of programs and agendas. All conditions and all possibilities are given for having a good discussion. Later on, we would introduce the panel participants. I would like to ask Mr. Gábor Valkó on behalf of the Central Statistical Office, who is the Vice President of the Directorate of Statistics. I would like to ask him to please give his presentation and I'm afraid he won't be able to discuss in detail in the form of the panel. So we are having a 20-minute presentation. Please collect and gather your questions, and then we will be able to discuss that later on. The floor is yours, Mr. Valkó. Thank you very much for the introduction, dear ladies and gentlemen, dear presidents, directors, dear managing directors. We are in an accelerated and fast-pacing world, and the utilization of the data assets is the title of the presentation. I'm very sorry I was a little delayed in my program today. It seems like the data market is faster than the public transportation or public transportation and traffic in a city. In the first slide, one of my favorite big data cluster is, it shows how much the world changed in the past period. In 1997, when Netflix entered the market, they needed 3.5 years to achieve 1 million users. And then 25 years later, when ChatGPT entered the market, they needed only 5 days to achieve this number of consumers. If you look at the KSH, the Center Statistics Office in Hungary, it is the largest data asset handler and controller. And we can see that data market is continuously accelerating, so we just not sit back and wait. We have lots of data tables, quick and short reference cards and tables and platforms are operated by us. And but I think this can be said about the platforms and areas operated by the companies of the people represented in this panel discussion. Actually, the pace of data generation has changed greatly. In the 1980s, we needed days to generate any type of data. It was related to any market transaction, buying a car or buying a property. After the year 2000, everything changed. We have smartphones, social media, the satellites, and it generated or it created a huge explosion in data generation. In 1 second, we have 4,700 terabyte data created. The 20 minutes of during my 20 minutes presentation, we have about 6 million terabyte data generated, and in the Google browser or in the Google search, millions of data were generated, or a couple of 100,000 messages were sent. So the data ecosystem pace has greatly accelerated. And the data market has changed greatly. Data controllers, such as the Statistical Office, doesn't have a monopolistic situation anymore. In the golden days, when there was only one player in the market, that has ended. There's a huge competition. Microsoft, Google, Apple, and similar players generating more and more data. which might be very important for users. What do we need to, where do we need to improve so that we can deliver accurate and trustworthy data to the users? So in this data market competition, we have to be have a leading role. We have to create good quality data that increases our prestige and the trust of our users, which is a good basis for cooperation. KSH's key goal is to enhance that trust and to be a leading player in the data market competition. What are these pillars for this? Data governance and active participation and the decrease of parallel or redundancies, parallel factors, and on behalf of the data suppliers to decrease administrative burdens and to create new type or exemplary or revolutionary pilot statistics and methods to create the best quality possible data. So let's look at the results of the past period. In the past 1.5 years, KSH is in the first at the first place of putting GDP data in the public arena. Since 2024, KSH communicates GDP data within 30 days. Previously, this was a 45-day time limit. So, and in addition, punctuality and has improved. So, if we compare the T30 and T45 data, the difference is 0. Therefore, the punctuality was not infringed. KSH is amongst the 12 best statistical offices that are the fastest in communicating GDP data. And as of 2025, if we consider all statistical offices in the EU, we are the first ones to communicate this data. This is a huge step forward, and we tend to enhance and improve this even more. We also shortened the communication of exchange data. For example, we provide quick guidance within half an hour of opening the exchange. And if you look at our publications in 2024, we altogether shortened the market entry timeline of our publication by 479 days. So if you look at all the publications made and published, obviously we still need to improve our product portfolio. We need to enhance automation and new content management systems. We have piloting statistics as well to be able to meet the demands of the as wide circle of consumers as possible. For the technological changes, what do we mean by piloting statistics? The members of the official statistics office produce or generate statistical data. However, there's a possibility to create pilot statistical data, which means that to generate the existing statistics based on new data or new methods, or to create new statistical data. And these pilot data may remain in the piloting stage. However, if they go through an evolutionary process and corresponding to various testing procedures, they might enter the arena of official statistical data. The most important is to put data in the public domain as fast as possible. AI application and use today is key importance for all of us, be it a social player or a scientific player or the players of the economic world. We need to we need to speed up, and we have to be able to supply good quality data. In the past period, transferring camera or CCTV data, online cashiers, and using public media and the websites. So the statistical office can improve its own existing methods and newly introduced methods. Let me introduce you a few forward-looking corporations. Together with Navu, we have a data supply and R&D project. Together with the university, Gábor Dénes University, and the Chamber of Commerce and Industry, we try to create a new AI-based query system in terms of SMEs, SME datas, and it can be a good compass for the small and medium-sized enterprises that they can access and data and position themselves for the future. In 2022, KSA started its Virtual Hungary project. This is a very important project as it's public administration and register-based data and large sampling or pattern surveying. And through anonymized processes, we created a database structure. We have multiple dimension data circles, and based on that, it will give us the possibility to either concentrate on data based on the number of people employed or the number of enterprises, or for any kind of players in the public arena. The VIMA's goal is to create up-to-date, detailed, and predictory data, and to be able to analyze various scenarios and to be able to demonstrate what probability changes might be expected, or what potential crisis can be expected, or what can be the implications of a change in law, or what can be the implications of a breakthrough in the world policy. And it's very important that by connecting the databases and the information extracted from these, it's significantly more than what were available in the original siloed databases. I really hope that I provided useful input for this panel discussion, and I hope that we might be able to share more useful information amongst our colleagues. Thank you very much for your kind attention.
Thank you very much. Again, before you go away, please allow me to give you a gift. on the right side of the table, who have been living for decades on utilizing data. And this is an interesting meeting that data market is considered to be a meeting point for supply and demand. So there's something in the shop window, and the demand has a look at the shop window and is satisfied. So I would like to present the participants to you. Vince Kruhina, Managing Director, National Data Agency Ltd. Who develops also his professional career, scientific career. Shall we modify? Shall we modify? Shall we add your doctor's title now? Not yet. He used to be the general director of state companies over the last years, and Professor Lapshansky is the deputy chairman of National Media and Info Communications Authority, and Dr. Tamás Tomor, Commercial and Business Development Director of EnviroSense Hungary Kft., and Zsolt Virág, Chairman of the Board or co-founder of Hi-Fi Labs ZRT. So, dear gentlemen, we open the discussion. Does anybody want to add anything to the introduction round? Maybe see it on the go, no problem. So from the business side, I would like to tell you that not everybody has a company inquiry database behind him. Mr. Virág is representing a company with 200 employees, fully Hungarian owned, and his markets are no longer in Hungary only, and the main profile is to utilize data. I think I have switched off your microphone. 2 sentences, yeah? Welcome everybody. Yes, we are a Hungarian-owned company with 3 Hungarian private owners. We have sales of 11 million US dollars. 50% comes from the United States, the other part from Europe. With the Hungarian state administration, we have some revolutionary projects. When we feel that in the worldwide we have done something which could be handed over to Hungary, then we are very enthusiastic and we want to transfer our knowledge to Hungary, but this does not succeed all the time. We have 250 people in Brazil, and we have a delivery team, and in London and New York we have also a supporting team. That's it, and I am happy to be here. I didn't know these numbers, but this confirms that data you can build upon also in Hungary, in the Hungarian business environment. EnviroSense Hungary Kft. is maybe not known to all of you, but also there, some 50 people are working, are using on utilizing space data to create business value for the market or for the public sector. Yes, EnviroSense Kft. Is owned also by 3 Hungarian private persons. We have 50 employees. So we have many international projects, but we work in Hungary. And we specialize in spatial data, and we build structured databases. We are the company that has a laser scanner survey of the Hungary with many pieces of information derived. Everything what is space, everything what has to do with the identification of buildings or land use or whatever, And we build services on the basis of this in the private sector, in the public sector, and also for the municipalities. So, Mr. Lapshansky, Mr. Kruhina, what do you do in your main profession related to data and data utilization? I think I need not present NMA. Both in telecommunications and media, we we control a lot of data. We also have to, we also have mandatory data supply activities. All data treasure is known from the law. It is publicly available because we are a state company. In the meantime, so some technical information is that I have to give the floor to different people using the mic to be interpreted. Mr. Gruhina took over last December. Company thank you very much for the invitation. This is my personal experience, and why is it important to have a NABU? We see that the government also on EU level quickly recognize that data, their different utilization will be a strategic issue both for the public and private sector. And then when NABU was established in the early 20s, Gábás Levente. So at the time, AI was not really publicly known. Rather, data enthusiasts cared about that. When I taught statistics at the university, we have found empty students' halls. Nobody attended statistical classes and everybody attended AI classes. So today it is exciting that with the help of IT, with the acceleration of the computing capacities, available data can be used in real time, which means also for us, for market players and also for the public sector, that resources can be allocated much more efficiently. We can make real-time decisions, and the target of NABU is to come back to the question and to understand the idea of the founding members is to have a methodological institute, a center, which has the task to optimally use data registered in the public sector for the sake of the public and private sector as well. And some spectacular improvement development projects are going to be launched soon. I think these are I think it takes some time at conferences, but it is important to get to know who is representing which standpoints. And this is interesting also for the audience, especially for our foreign guests. We could see a quick overview of the reform efforts of the Central Statistical Office. And the Vice Chairman drew our attention that everything speeds up, the volume of the data generated. Also, the processing speed of the Central Statistical Office is speeding up. The Central Statistical Office of Hungary is spearheading the statistical offices of the EU. We see also that they are all experimenting. I also had a look at the presentation of the vice chairman from last year when Virtual Hungary flashed up for a moment. And those who had it, so you had a look at the presentation of the vice chairman of the Statistical Office. What kind of impressions did you have from the presentation of the vice chairman of the Central Statistical Office? I was happy to see that the CSO finds it important to accelerate. Google knows much more about us than the state, and Google knows information about us for which or where you can be priced in a different way. So the companies who want to sell things, the information comes not necessarily from the hands of the state, which is a quite brutal transformation. We have to go ahead in this. And I think that my most important impression was in connection with the presentation that we have a strong problem awareness or go-ahead attitude. Would we go one layer deeper into the topic? Then the question is how much we can see the togetherness of problems. So that one data steward hands over the data to the other data steward, and there is no data jealousy. This is one of the major obstacles. And I know this is not a simple thing. So we have traditions. We do have some data, and these data are to be had only from all sides. So when we wanted to explain how good it is to combine different pieces of data, I tell you an American example. In America, it was a huge project that the state told to the insurance companies that all data have to be submitted, and they have interconnected them with the healthcare data, and they started to analyze the insurance sector and the healthcare sector in such a way as to how to cut costs in the healthcare sector, so that people are made to live healthier, to have a lower insurance policy, insurance fee, and we have quite serious projects worldwide. I think that the Hungarian state is so strong as to make industries to make this and that. I think that also on the side of the data, it would be good to step forward into this direction on a uniform basis. I translate this that Virtual Hungary application is of interest for you, how to put different kinds of data into one space. For example, for a business with registered office in Debrecen, is such a business happy about the changes at the CSO? I look at it from far away, but I welcome and I'm happy to see that public sector publicly authenticated data sector is catching up or spearheading with new technologies. I think that the CSO was created by the state, is maintained by the state. They have a dedicated role as to what kind of a role they have. So the paramount measure, the paramount value is the public authentication. What the CSO said, we believe it. Also, if the land registry office says that this is the boundary of your plot, we believe it. So the society, business accept this. So information provided by the CSO are being used at many places, and I congratulate to CSU that they think in terms of this. as far as the data-driven economy model that change over into it is concerned, we are at the very core of this. We are the element that by triggering a process, we build automated processes. We think that the world is functioning in the physical world. Physical processes keep it alive, and everything can be traced back to a geographical location. And in this way, to create data of the spatial data, and to link it to other systems, there are huge possibilities in this. So we are still at the beginning of these processes. Many processes are still human-driven. We have a very low number of automated processes. Of course, everybody wants to develop. We have a competition on the world market, so there is a promising change at the CSO, in the public sector, and with the municipalities, at least as the attitude is concerned. I agree with Jolt with this, that initiatives from the government are needed, because we don't like to make changes of secure things we think are secure. So I congratulate to the CSO, so the Central Statistical Office. Mr. Lapszewski.
No, not really. I don't wish to add. Being a state-owned organization, I don't think I could comment a lot in the framework of a conference. I might add general issues that MMS operate. We work together, we cooperate with the Central Statistics Office that is based on law or based on contractual framework. The geographical geolocation data is provided by us to the Statistical Office of the mobile phones, and based on criteria to guarantee that personal data are not put at risk, and we provide data based on travel or travel behavior data or travel-related data that might be of use for the government. We have a good relationship with the Central Statistics Office. Thank you. The position of managing director is interesting, because last year when we got together, it was just it had been announced months before that the KSH will take over the control of the data asset, the National Data Asset Agency. What is the strategical importance of the change in the owner or supervisory authority? What's the issue or conclusion in Hungary? First of all, it was a good move, because both the Central Statistics Office, actually I had worked there for 5 years, so I learned a lot. And the data exploitation, data usage, the culture of that, that's what I learned there, based on what a statistical office can become trustworthy and authentic. And the organizational culture can be also learned. And if I may a little bit diverge from this topic, is that's where the root of the problem is, what I want to discuss. Everyone is handling data. So the first statement is the Hungarian state was very sophisticated in putting together databases, how the EST, the health information database, and then the tax authorities database is very professionally handled. And obviously, in the Western world, the central data collection was different because based on the historical traditions. In Germany, there's no central data collection. The various states are collected and not centrally in a federal manner. So when we would like to create any data asset or cluster that would be useful for the citizens, for example, like the health care database, we could do everything about it. That in case of medical history, if there's an accident or something, it would be very good to go through all the prehistories and the predictive and methods, or drug buying, medicine buying behaviors, if they are willing to pay for medicines or not. So what do we have to face in all this? The GDPR. So there's the analysis, pseudo-analysis. We have to turn to this authority, to that authority. So I'm a market player as well, because the state is a market player, of course, in the economy. But if I infringe the law, I will not be taken in front of the civil court, but to the criminal court. So whoever represents a state-owned company or entity, it has the approach is immediately different. In Hungary, there are very smart people working in these systems in a progressive manner. However, the legislation is lagging behind, and not only the domestic legislation, but the international legislation. If we look at the AI ChatGPT, don't know if we have a small healthcare enterprise in the family, and if you have a diagnosis and you go to a laboratory to have a test, and you don't want to wait for your doctor, GP, to interpret the results, and if the AI, the ChatGPT, provides a good enough opinion, or almost as good opinion as the GP, and then I can send this data to Dallas or wherever to have a second opinion. Do I care what happens to that? Because I get a good solution or a good service. So can the Hungarian government system do that, so that these lab tests or lab results could be perhaps analyzed by AI, ChatGPT, in a very efficient and fast way. But we are burdened with such obligations as part of the GDPR. So when we used to think that data should be protected from the state, but these data should not be protected from the state, but perhaps from other market players. And the generation has grown up in the meantime who don't care about their data, what happens to their data, because mobile phones and all other devices know a lot more about us than what the GDPR intended. So whole of Europe would send their data to Dallas or wherever, and those who work abroad are in the lucky position because they can work in a more liberal environment. So that is where we should create a dialogue or a legislatory favor or modification, because the EU and Europe will not be competitive in the data analysis field. But it's not only data, but documents and other language-related issues. Nowadays, if a company submits their demands for CAPEX and other indicator issues, we can only do that in an anonymized manner, and now AI does this without having any concerns about privacy or data protection. What will happen? This is what's being used. Users use these kind of applications, and I think technology is so far advanced compared to the legislative framework, and the world changes so fast that we are not talking about years here, but months at most. And the United States or China and those countries who are less concerned about data protection, they will overtake us, and we will have such a competitive disadvantage that we won't be able to make up for or catch up with. Sorry for this little lengthy remark. It was very good. It was very good. And this conference is organized in the auditorium maximum of a legal university, because the students who are educated here should be more aware that dealing with data and having requirements about data is very important in this century, and it does not only mean system architectural tasks. Sorry, I would like to mention another classical example, clinical drug research. Several pharmaceutical companies approached us. They would like to know if the data of certain patients with high blood pressure or with low educational level, that's what they need. That's what they would need, a person like that for their testing. So, and we told them we cannot publish such data of a person. So they had to look for patients in the US, because there the regulations are not so strict. And several drug researching companies told us, so why are we here? If we go to the US and we request patients with the same profile, and then that person will decide if they want to enter that clinical study or not. And one more example, as we are at the university, just to see what disadvantages, I just wanted to say what disadvantages it may have in research and development. So the ball is being bounced in your field, so who wants to push it? The health industry, health sector is very exciting, because just recently we put together a similar system or issue that Vince mentioned. 6 years ago, when GDPR did not exist, a law firm approached us from the US. In the US, they use a precedence law, and they said they would like to find a similar case. Yeah, okay, but these cases in Hungary are not digitalized. If you have ever seen an American film, but legal films, you know that there are lots of young students or long apprentices, interns, who would do this data mining. However, we had to search in the amongst the structured data. It was a very hard task. We didn't have LLM models like today, but we had to do this. It was a 1.5-year project. And then we could say that by the time the legislation came, we have seen these kind of expectations. And AI disrupts our own industry. You won't need programmers in the future. So perhaps everything will be solved by AI. And we are transforming our company so that programming tasks are performed by AI. And regardless of that, there will be tasks to do because someone needs to explain what the business need is or business demand is. Yeah, okay, this will happen. Oh, we would like a system like that. You know, whoever specified an information technology project, it's very difficult. So you come in, you tell what you want, but a button is pushed, it will be programmed. Okay, you look at it, and then you say it's not good. But only 2 days passed, and you haven't spent millions of forints, but the AI will do another modeling, and then you will find a good one within a few days, and not 6 months will pass. So you will have time to specify things because it will only take a month still, even if it's the 10th attempt. So if you are afraid that it will disrupt your work in your industry, we are also concerned about this. And I think it's important, and it might be a competitional advantage that data before 2017 might be key, as these are not digitalized or not structured in a way. However, I think structured data use through AI is a very important function. And of course, you cannot upload everything in the cloud. I'm not advocating for that. However, as Vince mentioned, there are certain fields where it can be used. And the other thing is that how many professional people worked in the state-owned entities who could write SQLs? Very few. The state could not pay for it. And now AI gives you the opportunity to give you free text. You don't have to write an SQL. So this change will take place. These changes will take place. And it gives you the opportunity to make 2 steps ahead. We are lagging behind to some extent, but these possibilities give us the opportunity to make two steps at the same time. Thank you so much. Professor Tomor, Professor Rakshansky, are you exhausted because of this discussion, or do you have any other to add? I don't want to burden the audience here based on industrial or any other concepts. I could argue with what has been said before, but a panel discussion is not a forum for discussing the details. And I agree with many things, however, and the sensitive data is even more problematic. But if we take example from the media, I think we have to be very cautious to evaluate the market and economic aspects in these forums. Because if you look at telecommunication sector, which was a huge fever in the 1980s, that in the public utilities you don't need a state-owned entities and their work methods, and now everything explodes as a result of the AI, and we say we don't need this and that and many things. But I think we should have a very relaxed approach to this. And I must say, in many public sectors, lots of market opening took place, and all data circles were opened and made accessible by the market. And within 3 or 4 years, it turned out that in the Anglo-Saxon model that was highly advanced, where they decreased to the minimum the state intervention, in most cases, they had to take back, or they had to take a step back. By the beginning of the 1990s, in all the public service sectors, there was a huge halting. There was huge damage suffered, like the British rail privatization and the related expenses. It had to be reversed because they did not think about or they did not predict such consequences, and they didn't consider that everybody with their train want to stand between 9 a.m. and 11 a.m. on the train stations, and the other time windows are less popular, and in those intensive time periods, there was no capacity, actual infrastructure capacity to serve all these needs. There were only two sectors that were successful in implementing these issues. The telecommunication and the air traffic industry. The marketization and the privatization intent that was started out came to a halt, and they realized in the railway industry that it was a huge hooray that it started, but then in the meantime it turned out that actually air traffic control cannot be privatized to that extent. Because if you privatize it to some extent, that given airlines flight will arrive, however, the others, the competitors, might be disadvantaged in that case. So you have to think very thoroughly about these steps and actions. I don't want to contradict if these are possible or viable and feasible or not. I just want to say that you need to think it over very thoroughly, and you need to consider the AI's sudden popularity, so let it skim down a little bit. And the last thought, I'm convinced that that in the telecommunication industry, the quality, nothing is transformed by AI in terms of its quality. It's just a question how you utilize this new opportunity. AI will not revolutionize the quality of these sectors. It just gives you a different tool or a different aspect. And just like in the public administration sector, for 100 or 200 years, a traditional method was used, and then 20 years ago, a new way was introduced, and it provided a new channel, but not a totally new procedure. As far as the authorities are concerned, they have to use the same well thought out procedures, and the same procedures are used, but only the means, the channels are different, like the electronic platform. Thank you very much for your comment, dear Vice President. I think we got quite a good picture through these classical examples at what changes took place in the market. And we can see that the state has room for intervention. And last year, when we had the same conference, it was a relatively new law on the National Data Asset Utilization Act, which was the Act 1 of 2023, and it talks about the activities and actions to be taken in terms of the national data sets. And there were some predecessors in terms of this law, but it had to be modified to be able to align it to the EU intentions. And this law is being implemented in phases, and for our foreign participants, I would say that there's another law, the Digital Citizenship Services Act, and we can see that you missed in terms of public administration activities. And what we think is important in terms of utilizing these data clusters and assets, or the data wallet issues, or data exploitation services. So we do have the devices and the technology. These exist in the regulatory framework. These are used in the projects. How do you assess, or how do you evaluate those quick and fast initial responses that the Hungarian government gave? So what experiences have you gained, like the National Data Asset Agency, for example? I would come back to this question, but what my colleague here said, it's very important that Stone Age did not finish because there were not enough stone. So the world will change, and if you look at it from a regulatory aspect, I look at this from the aspect of an economist, not as a lawyer. State regulation can be enforced where a state can actually really enforce its power. So in case of natural monopolies, you need to have a regulator, because if you privatize or put it in concession, you need to have rules. But what happens if state as an entity is unable to enforce its rights, like in case of AI? Obviously, we cannot disconnect the cable at the borders, neither at the La Manche Channel. So IT, if it's good or bad, so how IT can regulate, or we can regulate, that my data or other people's data, if I want to send to the cloud or to somewhere else my lab test results, the regulator will not have any impact on my intention. And if I connect it to the laws that you mentioned before, the state has a role to create alternatives here. And the amendments to these data asset laws, in that case, the state needs to give alternatives, like it's your decision to upload and send your data to Dallas somewhere in the US. You can do that. But when we have a role, we develop applications to provide alternatives for our citizens. That if we cannot regulate your behavior, but you are a taxpayer and you would still like to have some kind of a data security, then we provide an alternative platform to you that the state has any kind of supervision over. And if you use that, we can take certain or provide certain guarantees. So in the case of all these databases like AI, we need to provide alternative systems or applications that are competitive against the other solutions provided by the tech companies. So data available to the Hungarian state are a lot more precise than what AI can generate. Just an example, ChatGPT, it's very difficult to answer by ChatGPT how much was the average consumer price index in the 2022 and 23 year, because in general, people will only talk how much or how will it be in 2023, 24, and so how much it was. ChatGPT focuses on how much it will be and not on the actual data that was registered in the statistical databases. So it has a difficulty in referring back to actual data. And if we ask the ChatGPT what is the status of the foreign exchange or the exchange, the stock exchange, because these databases are blocked, so ChatGPT doesn't have an access to these. But if the Hungarian state would decide to give access to these databases to ChatGPT, then we can give an alternative way of usage to the users about which citizens would think that it's worth paying your tax to the state. But so as I mentioned it in my previous comment, this is a legislatory revolution, what is needed here, because you have to be able to make some kind of a regulation implemented, because otherwise you are just a toothless lion as a state agency.
And those who participate in the discussion know more than the average market payer. But anyway, it is hard to keep track. But law was made, an act was adopted for economists and for did influence the work of Viros Kft. And the services regulated by the law, or that organizational data commissioners are appointed. Did this change anything between the public and private sector? No. Short answer. Of course, it is also the legislation and the application of the law is very important, but the application is very important. Everything is worth as much as we implement it. Of course, it is necessary to regulate it. The world of data, the world of public data, they use, and how it goes down to the bottom of the pyramid, we should not forget. Because at the end of the day, we have 10 million citizens, 400,000 businesses are producing our GDP, and the GDPR is preventing them in that. So we are absolutely hindered by the GDPR as actors on the data market. So I cannot add too much to this topic. I don't know the legal rule either, because it is not linked to our everyday business practice, just from far away. But I would like to add something to this topic. As told by Mr. Bince, it is very important to have a look that we have to split the quality of the data and the devices used for these data, and the data structures used for these data. So the data industry is a breakthrough point for Hungary, and we should say it in clear words, and we should promote it. So we have a creation of knowledge in this technology. There is a huge competition. Also in the States, Hungary has very smart heads and IT people working for abroad. Why not prompt them to implement the alternatives discussed by the managing director? So as the CSO is a publicly authenticated data provider, so the state can also appear as a authenticated data provider, and it is also the owner of an authenticated data structure. including the public and the private sector data. So in this, the state is still spearheading the market leader. We have huge reserves in the establishment of data infrastructure, which will be unique and nobody else will have it. And if the state keeps it and builds services upon it, then the state can be a real competitor. Also in front of giant companies. So in context, I want to tell that it is to be welcomed to have state interventions which, first of all, would express within the annual GDP the ratio of the data and the working ability of data within the GDP. I wonder whether we have any study about that. But this is the danger. The enemy is at the gates. The National Economy Ministry had a presentation where they said that the position, the number of workplaces endangered by AI was an estimated 3 million within a few years. Also in Hungary, at our company, we have been using AI every day. Half of our projects, the time needed for the projects became shorter. 50–40% of our work is done already by robots. So this is rapidly changing the lives of economic actors. So this is something we have to deal with. Does it mean, Zsoltvilág nodded as well, does it mean any change that we have a clear-cut picture of the roles? Did it mean any change in the recent years that states started to regulate the space? I would like to join in into what Tamás said. We are a bit far away from these laws. But we have, for example, business data. Bank can buy business data from Opten. And Opten has bought from the Ministry for Justice. So the Ministry for Justice handed over this information to a company, and Opten has bought also this company. This is an information which is owned by the state, but the state was not in position to bring it into a shape which would be attractive for banks to buy. So banks needed up-to-date information from Opten about businesses, but the state could not give it to them. But such things happen. Another example from the United States, $5,000 billion are invested based on the data platform we have compiled within half a year for the third largest risk capital investment company of the world. They know everything about Tamás, for example. They know whether it is worth to invest money into the company of Tamás or not. What do they live from? They want to invest at any point in the world. It doesn't matter how much Opten sells company data for. So they need data real time. They also have to know that if their competitor has invested money into the other company, whether they have won or they have lost. Is it better to bring the companies they invested into to the stock exchange or not? This was a project we could compile within a half a year. And just a joke related to the presentation, when the whole was, when we have made a demo in New York last December, it was not exciting whether in the demo the data mining models would be good, but the important thing was to look good. And we started to polish it perfectly, the database, and the Americans said, you will not need it, but it should look like the applications. That was the important thing. So I tell it to you that sometimes we say CSU and accurate data, and yeah, it is important. But it is also important that the data for the citizens, for the users, how you can make data graspable, digestible to the users. This is very important. I think in Central Eastern Europe, we think this is an overkill, and American presentation is too much for us. A Hungarian presentation in the States is not enough. So we have to bring content, but we have to also present something which looks good. Thank you so much. 9 years ago, the Visegrad countries appeared that we would need a nationwide data policy, and at the time the National Telecommunications Council made a policy like that. This is already 10 years old. Now we might come to the conclusion that this shop window, which is being built at the crossroad of public and the private sector, should set the boundary until which line we have to put data, and we have to put connectors. What is the task? What is the task of the market? Where is the boundary where the Ministry for Justice organizes the services and gets the sales? I don't know whether Anton Stropczynski wants to tell something about that. It is always useful if the regulator and market actors meet at venues or at different locations, because pieces of information are exchanged which promote both players. So the logic behind the regulation is that, and the legal thinking is, yeah, GDPR should be reviewed. This is what it says. This is a kind of axiom on this market and in this area. And I don't dispute that. And the logic behind the regulation in the EU and in Hungary, we are a little bit stepping behind, standing down. But the market logic and what market actors say is one aspect of the things. Regulation, intervention into the society is a huge responsibility, and it shapes such relationships. I would like to draw your attention to one aspect. What the managing director of NAVU said. These are aspects. So the fact, if we upload some data, and how AI is reacting on it, and how we should allow this, we should give alternatives and so on. So public authentication is very important. So the public data treasure is added something, some additional thing by the state, if, for example, it is in the AST application. So we should not treat the data just as an asset or market possibility, because the public authentication system says it is more, because the data shall be deemed as real and accurate until the contrary is proved. So it is not sure. It is not sure that the state has to offer an alternative in this, so that somebody gets the result of it, and where they upload the result or where they inquire or extract information, this is their own right and decision. But if the state opens up something, then they open up publicly authenticated data, which represents a different value. And that's why so we should not leave time, because we have no time, but we should add these aspects when thinking about these topics. So with the state, the data is not just something which can be used on the market. This is publicly authenticated data, and even US people know that. But that European way of thinking is more conservative. And maybe we have to review it. But no hustle is allowed. We should not be hasty about that. So that time is passing by until the panel meeting is closed. We still have some things. So, in case you could raise questions, how many hands would be up? And I would also like to ask Gabor to say the closing words. And Kovács György is also here, and Gercsei Balázs will also evaluate the session next door. And I would like to open up a firework-like round with half a minute of contributions. Is there any data utilization practice in sight these months in Hungary where you would say, okay, that's good? And if the colleagues could say some examples where this meets with the market, it would be also good. So I look forward to DAP as such an application. As a market actor, we see a very exciting experiment where spearheaded by the state, and they created a platform which to which also market actors can join, and based on live situations, they can offer also commercial services to the citizens or to anybody who is a user. I think this is the biggest shot. I would like to join into the medical care topic. In the business life, we think in terms of use cases. Just imagine the situation: you go into the hospital, you tell your social insurance number, and you go to the internal medicine department or surgeon or whatever, and there, in 10 sentences, everything would be summed up about your medical history. This can be done. I told this also to the Ministry of Interior, and he said if somebody has an AI idea, then we should tell it. I told it to him. In Hungary, when I go to the doctor will know what happened to me in my life before. And we have many such use cases. So we have plenty of them, of such use cases. Do you see anything at NMH? Hírközművön szélessáv.net is used to disseminate such data between the public and private sector, which is reachable over web pages. I think one thing is the DAP. If we further improve it, it will be very useful, both for the market, both for the citizens. it will be successful, as Danish said it. So the economic ecosystem we are developing, if a business sector wants to set up a company, then if they enter their TAO number, then we can analyze all the data that we have, and we help business sectors make business decisions. We hope to implement this in August, September. We can produce a service we can be proud of. I can upset this as a closing word now. We would open up the space, and everybody who is listening to the discussion will get a mobile microphone if this works.
Thank you. My name is Tamás Penny. I'm one of the Hungarian authorities, NAIH, and I feel together with the lawyer community, and I know that your perspective determines your positions or your point of view, so I could hear some other perspectives. I don't want to defend GDPR because it's not my task, but I would like to react to Zsolt Virág, to what you said to the Ministry of Internal Affairs, that GDPR is not against that. GDPR regulates a lot, but it prohibits very little. And whatever it prohibits, it's under a certain set of conditions. So whatever was mentioned by managing director as use case, that could be implemented in GDPR compatible way. Peach University had a project like that, for example. So I would like to suggest that please don't believe everything that you hear from law firms or data protection lawyers, that something is prohibited or it's not possible, not feasible. It's a different question that it might be expensive because the EU renders such set of conditions for a certain function or area, because child labor regulates differently, regulated differently by EU than in China, and obviously those the products that are made without using child labor are more expensive than in China, but that's based on, that's a matter of decision. Cloning is, for example, prohibited. But what happens if an international actor deserts from these treaties and they say that they are allowed to clone from now on? It has a price to pay. So please don't believe that GDP will prohibit anything. It's not prohibited, but it has some set of conditions. I feel ashamed because I didn't have as much awareness that to bring Tamás's nameplate back when the vice president of the statistical office left the conference. So you should have a place here. Anyway, we wouldn't have more place on this board. And just one very difficult thing is coming up or forthcoming: the AI created content, the legal handling would be a huge challenge. Who will be responsible for for handling those contents? Is it a speech, a video? It's an edited content, so there will be lots of tasks to do. Victoria Zelena, on behalf of IDOMSoft, reflecting to the previous commenter that please don't believe everything what you hear about GDPR. So I think this concern or fear, if we should divert from GDPR, it's more prominent in Europe than in the US or China, but we should still try diverting to some extent. But if we are talking about trust and fear or concerns here, and I'm trying to use subjective experiences, no, it doesn't matter what's written in the GDPR if only 3 people dare to do something about it or dare to do something under that or according to that. So coming back to the issue of trust, is there any research experience perception that a European citizen prefers to upload to a service provider in Dallas than in their own country, for example? This question occurred to me because we don't know what happens to the data. But a company in Texas, for example, or Dallas, they don't know who I am, and I don't know who they are. But when the state learns about me, what kind of disease I have, then in 5, 8, or 10 years' time, they can make an impact on my life because they have this possibility to use this against me. I don't know if you can still follow me. Is there a tendency worldwide that everything is possible abroad, or whatever happened in Las Vegas, it stays there? So we trust more in unknown people analyzing our data than those in our own environment, our own community. This is my question, if there's any experience. Have you seen this? I think we have. This is the failure of the state. That's why the state, that's why there are market services in addition to the state services. Healthcare sector is like that. The citizen doesn't trust a service, therefore turns to a market player. And if they feel that they get a better service from the market player or from a foundation or and they want it from an Anglo-Saxon market player. So I think we have seen examples, but we have seen counter examples too. I worked in the ORTT as an intern. So as far as news consumption is concerned, by the question of authenticity, state-owned television was always thought to be an authentic source of news and information. I don't know what's the situation now, but obviously there are services in the healthcare sector where the citizen might think that the state is able to provide more authentic service than other players. If, for example, a laboratory has a stamp on their operating permission, saying that they are able to provide appropriate services. So the question is, who can influence what and who? Obviously, the state can take advantage of data provided to it. It might have a monopolistic situation. So I think market companies can influence more, or the tech companies have a larger influence on our everyday life than the state. Perhaps it will turn back. On the ChatGPT or AI, there are no advertisements at the moment, but I'm sure we will be targeted by thousands of advertisements by ChatGPT. So if they see that you are interested in the health sector, it's just a matter of time that you will be targeted, or we will be targeted by various targeted advertisements. I don't know if I answer your question. Change is continuous. Google actually grabbed the marketing activities. All marketing offices lost their business. AI is not Google search anymore. So what will happen to marketing activities? We don't know. If these banners will be included in the AI engines, or okay, Google won that battle, but now there's another player in the market. So if one of my colleagues would sit here, they would say that certain data certified by the state, that's an attribute. If it's done or not, it is just an attribute to that data, but it's a value. It represents a value, an important value. But when you design a house, then you have to be very thorough. You don't want a wall to be 2 meters away. But if you are playing in the sandpit with your child, you don't need to be as specific and punctual. So there are some data where you need authenticated data or power, and if you send your sample to somewhere and you believe that that company is an authentic source of information, so marketing can misrepresent, or can be a reason for misrepresentation in many cases. But I don't know about any official survey or anything like that. But when you send a saliva sample to a laboratory and they perform a DNA sequencing, and that can be done by the state at the same price as by that market player. So if the state would look at what kind of industries has started out or have started out around data or usage of data, then the state should follow and should react. And the question is, whose role is it within the state who can make money out of those data circles that are available? So why not the state? This would lead to the updating of the national data policy. But I think if you use excellent ingredients for a soup, you can make a very good soup. Therefore, we had excellent players here, so I think we made a good job in making this fine recipe. So I thank you for your time and energy to come here and get immersed in this professional community, because we can see very good and very reputable experts here. I would like to ask Gábor Csomán to please give a summary through your somewhat outsider glasses or spectacles as to what you thought important or why it was important. And I would also ask György Kovács to make a summary of their own panel discussion. Gábor Csomán, I'm the Zoltán Magyari E-Economic Association, or E-Government Sciences Association. When we organized the first Data Day conference, I was the moderator of the last panel discussion, and I was the one to give the last but one speech before lunch, and it's always a hard task. I try to be brief. And another déjà vu feeling I have is also related to last year's Data Day conference, because by the last panel discussion, we got into a position that when the discussion intensified, just like now, Last year's conference experience was, if I may talk about this secret, I think I may take the liberty to talk about the organizer's secrets. When last year we summarized the conference, a lot depended on these panel discussions like this today. So last year we started the organization work immediately after closing the conference. So I think we also started organizing next year's conference yesterday after 2 p.m. My impression is that this conference is needed. Therefore, we would like to organize it next year as well. With that said, we will pay attention that these kind of panel discussion and exchange of views should also get a focus like this year. And the novel thing about this year's conference, we opened to international partners, to EU organizations and other foreign countries and representatives. And the feedback from yesterday was that it was much needed. And it's very important to channeling in their views, and I think it added to the value of this conference. And both the Hungarian and EU regulations and regulatory framework should contribute to the extension or enhancement of knowledge. And one more secret, last night we had a correspondence with my organizer colleagues talking about next year's conference and what we need to pay attention to. And we started discussing about the actual projects that we should or we could implement. And perhaps this was the purpose. This is one of the purposes of this conference, to raise ideas and to create and generate cooperations and discussions. And last night, between 11 p.m. and midnight, I got the reassuring feeling when I heard from one of our experts that they are able to read about fishery at 11 p.m. And think about these issues, as we heard from one of our participants. So it was a reassuring thing for me. And I really thank you for your insights and cooperation and contribution. I think we created a very valuable discussion, and I hope we will have the same next year. And as closing words, I would like to thank the Peter Pázmány Catholic University and also the Ereki István Public Law Research Center and all the other entities who supported our event. Thank you so much. Nem tudom. Meglátjuk. I warmly welcome everyone. I'm the digital technology English program of digital education for lawyers. I was given two tasks by my institute director. First is to say a few words about lawyer education program, and to summary the parallel section in the nearby room, what we talked about. So the English language, digital technology, lawyer program or law program includes the EU lawmaking related to data generation and data handling. And it was also complemented by AI-related studies and cyber crimes and media law materials related in this field. And as a result of that, we are very grateful for the Ereki Research Center and Balázs Gerencsér, director, who embraced the panel discussion consisting of the instructors of this program, law studies program. We used a different structure. There were consecutive presentations given. So to be fair, I would like to say a few words about all these presentations. Zsolt Zsődi, professor, talked about the latest tendencies of the European platform regulation and the dilemmas, emphasized that the EU regulatory framework becomes more and more complicated, sometimes following contradictory laws, contradictory goals and purposes. The key regulatory devices like DSE, DMA, and the sectoral guidelines or the implementation of these guidelines are made difficult sometimes, and the transparency requirements are not very well implemented, and compliance with laws requires significant EU intervention. Szabó Endre Győző, another presenter, highlighted that the new technologies like AI gives relevant, significant pressure on the protection of privacy. Therefore, the rules of societal cooperation needs to be maintained, and we have to apply risk-based approaches, and transparency requirements should be determined. Viktor Botka, who is a member of the legal service of the European Commission, and also talked about the regulations related to the AI and the competition-related implications, like antitrust rules should appear in new forms in terms of the new technology, and new set of responsibilities are raised. Pap János Tamás, the instructor of our faculty, the media law changes were scrutinized. For example, what impact the AI has on the news media, and that the conventional media regulations and guidelines need to be changed and represent new challenges nowadays, because the contents generated by AI causes difficulties and challenges for us, and we should seek alternative solutions to preserve the authenticity and trustworthiness of mass communication. András Pünkösdi was talking about the data strategy of the EU and the ambitious goals, and the 2021 and 2023 and 26 purposes and goals were scrutinized, and the EU provides several devices and tools like generating and building up common or shared data spaces, and the EU is significantly lagging behind compared to the US in the field of digital infrastructure and investment. And Dorka Tamás was dealing with the latest devices and technologies and how to implement these. Adam Wojkowski is the permanent representation of Hungary in the EU. The latest developments in the EU regulation focusing on the cyber security and the impact on the economy. Talked about the latest EU laws like the Cybercrime, Cyber Resilience Act, and Cyber Solidarity Act, but he also talked about DORA. And János Cyber talked about freedom of speech and data protection, the online platform shadow banning problematics, and talked about how platforms can limit the visibility of the user content, and that what challenges this sets for the EU regulations. And finally, Kinga Sorban, about her presentation about the novelty of the European regulations regarding online crimes against children and how to combat these. And she stated that younger generation using community media significantly increased. Therefore, AD, MSD, DSE and other devices or interfaces introduced by the EU were discussed, and platforms against the sexual exploitation of children, and the draft regulation for that was discussed, and platforms have more and more tasks and challenges regarding these issues. These are the presentations that we heard this morning in this parallel panel discussion. And now, after lunch, Adrian Adzel-Partos will be talking about artificial intelligence and the use and of that and inclusion in the curriculum, and data protection, compliance, actual issues of compliance will be also mentioned. István Kun, on behalf of the Media Authority, will talk about public law, administration and statistical data analysis, and the digitalization of the public sector. And then Daniel Eszteri, head of department, on behalf of the Data Protection Authority, will talk about AI-based decision-making and profiling, and what data protection challenges it has, with special regard to the neural data. And finally, Gergely Rideg will talk about the responsibility-related issues of AI, and I will talk about CDSM, digital internal market copyright issues and copyright concerns. And these presentations justify that English language, digital technology and data asset management lawyer program is inevitable to prepare our young lawyers for the challenges in the future. And this program has an interdisciplinary approach with international prospects and outlook. And the AI Act regulation, or the focus on AI considerations. Actually, the application date for this program is the 20th of July. This is a new program which will then start in September this year. Thank you for your attention.
Tisztelt Hölgyeim és Uraim, akkor a
Dear ladies and gentlemen, for the next 1.5 hours, please relax. Just one more thing. Thank you very much for the great summaries to Csamer Gábor and György Sándor, Gábor Csaman and György Kovács. And there's one more idea to take home with you today. So the day-to-day wants to build a bridge. So the most important target of the day-to-day is to create a bridge between the actors of the economy, public sector, private sector, the NGO sector, and other stakeholders. We want to build a bridge between international and national players. We want to create a bridge. Yesterday, with global North, global South, with the international contributors yesterday confirmed that. And also in this bridge building, we can see that education, the bridge between education and research, we also want to create. We want to give a framework year by year with this day-to-day where everybody likes to attend, specializing in data economy, data strategy. You are kindly invited to be present also next year. As you heard behind the stages, we have started the organization of next year's event, and now we would like to invite you for a great sandwich lunch in the lobby, and please continue your liaising and relationship building activities. Thank you very much for your attendance online and also in person. Thank you.